Kent Berk. I'm an attorney at the Scottsdale, Arizona law firm of Berk Law Group, where we handle estate, probate, trust, and other types of cases. So sometimes an issue comes up of whether a person who killed another person is entitled to benefit by the deceased person's estate. Arizona has a slayer statute, ARS 14-2803, that deals with that situation. And basically the statute is based upon the strong and long-standing public policy that a wrongdoer cannot benefit by their wrongdoing. That's pretty common sense. So under this statute, if a person is found guilty or liable for the felonious and intentional killing of a person, then that automatically cancels any disposition to any disposition in a will or irrevocable trust from the deceased person to the slayer or the killer. It also cancels any appointment as a personal representative or a trustee, and cancels any joint tenancy property or severs any joint tenancy property. So if they own property as joint tenants with right of survivorship, it would sever that and make it so that they each own their percentage interest. And there's other effects as well if a person is found guilty or liable for the felonious and intentional killing of the deceased person. So you might wonder, what is felonious and intentional killing? And that's defined by the statute as either first-degree murder, second-degree murder, or even manslaughter. And of course, if they're convicted in a criminal proceeding, then that finding is binding in a civil proceeding or a probate proceeding to determine whether the slayer is entitled to be a beneficiary of the deceased person's estate. So hopefully that's not a situation that will arise very often. But if it does, if you have any questions regarding a situation involving a potential a slayer or triggering the slayer statute, please don't hesitate to contact us. Thank you.